question says, a man from state A was visiting his relatives in state B to celebrate the 4th of July. The man lit off fireworks and injured a family friend who was domiciled in state B. The family friend sued the man in a state B court alleging negligence. The man had never been to state B outside of the 4th of July weekend. The man answered the complaint denying negligence. 10 days later, the man amended his answer to allege that the state B court did not have jurisdiction over him. The state B long-arm statute grants jurisdiction to the extent that the U.S. Constitution allows. Does the state B court have jurisdiction? Here, the subject is civil procedure. The legal issue is, does the state B court have personal jurisdiction over the man? If you were struggling between personal jurisdiction and subject matter jurisdiction, go back to the facts. The fact pattern says, 10 days later, the man amended his answer to allege that the state B court did not have jurisdiction over him. So this is your signal that personal jurisdiction is an issue because it says over him. In other words, over the person, not the subject matter of the case. So what is the rule of law? A court can have a general personal jurisdiction or specific personal jurisdiction over a defendant. Whenever you are working your way through these problems, always start by asking if general jurisdiction is present. If it is not, then go to specific jurisdiction. General jurisdiction arises when the defendant is domiciled in the state, is present in the state when served or has continuous and systematic contacts with the state, or otherwise consents to jurisdiction. Here, none of those situations are present. The man was not domiciled in state B. The facts say he was visiting his relatives in state B. There are no signs of presence. He was not present in the forum when served, and the facts do not show any continuous and systematic contacts. And he did not consent to being sued there. This can be express or implied. We don't have any facts indicating express consent, like him expressly agreeing to being sued there. Implied consent arises when the defendant fails to object to personal jurisdiction in their first answer. The idea is, if it is that unfair to sue a defendant in a specific state, they will object to PJ right away. And if they don't, it probably is not that unfair. Here, the man did not initially include an objection to personal jurisdiction in his answer, but he did timely amend his answer. Remember, you can amend your answer within 21 days as a matter of right, and he did so here. All right, so no general jurisdiction. Now let's go to specific jurisdiction. Specific jurisdiction exists when the defendant has minimum contacts with the state. Those are the keywords, minimum contacts that do not offend traditional notions of fair play and substantial justice. Even one contact with the state is enough to grant specific jurisdiction, so long as the lawsuit arises out of that contact. Here, the defendant engaged in conduct in state B. He lit off fireworks and caused an injury in state B. So the lawsuit arises out of those contacts with state B. So the answer is that the state B court will have personal jurisdiction over the defendant because of those contacts. Now let's look at our answer choices and see which one reflects that. Let's start with the yes answer choices. Answer choice C says the man impliedly consented to jurisdiction. So this is basically saying that general jurisdiction is present because the man did not properly object in his answer. Ordinarily, one needs to object to personal jurisdiction in one's first response of pleading, in this case, the answer. However, under the federal rules, you can amend your pleading once as a matter of course within 21 days after serving it. Here, the facts say that the man timely amended his answer within 10 days. So there is no implied consent here. Answer choice D looks exactly right. It says yes because the man engaged in conduct in state B that caused an injury in state B. That is perfect. That is exactly what we said. Basically, the court has specific jurisdiction over the man because of his contacts with the state. Let's check our answers by looking at answer choices A and B. A says no because the man did not have sufficient minimum contacts with state B. This is incorrect because lighting off fireworks and causing an injury in a state will satisfy the minimum contacts requirement as we discussed. And this makes sense because the state will want to have jurisdiction over a person who causes harm to another person in the state. And it does not offend traditional notions of fair play and substantial justice. If you light off fireworks in a state and injure another person, you can fairly assume that you may be sued there. Answer choice B says no because the man timely amended his answer to raise the objection to personal jurisdiction. Here, that is a true statement. He did timely amend his answer. However, even though he raised the issue in a procedurally correct manner, that does not mean he will prevail on it. A court will still find that the state B courts have personal jurisdiction over the defendant for all of the reasons we mentioned.